and indicate whether or not you think such a challenge could succeed.
I see that one of the fish rod accused persons, as they are famously known, brought a challenge of that thought in the High Court. I don't know whether it is Hatwikilipi or Gustav. I think the full bench said, I know the majority decided that that section does not seek to violate the accused person's constitutional rights. It held that it is not couched in a wide manner so that it leaves room for ambiguity. In a bail application, we are there for bail, and then this application is brought. I'm not sure what counsel is really seeking now, whether it's to be heard on bail or is challenging the constitutionality of the section. Otherwise, I feel that debate has been settled.
Very well. If you are faced with this type of information that you receive from legal representatives that they want to bring a constitutional challenge in the middle, at the commencement or in the middle of a bail hearing, again, procedurally speaking, how would you address the situation going forward to ensure that the matter comes to finality?
I can't bar them onto how they want to, or which application they want to move. But then they should be very clear onto why we are there. Are we there for bail application, or perhaps they are challenging the constitutionality of that section? Because ultimately, if they are now bringing it in a bail application, I feel it might seek to prejudice some other interested persons. I'm sure the AG's office might have an interest in that. Now, if they are bringing it at that stage, I feel it would have been brought either in the wrong forum, or they would have misjoined or left out other parties that would have. So I would have difficulties to hear them.
Very well, thank you, Chief.
Thank you. There is a question from the Deputy Chief Justice here for you, Mr. Simasiku.
Thank you, CJ. Mrs. Simasiku, two things I need clarity from you. The first is that you have shown interest in the criminal stream. Now, once you are appointed, or if you are appointed, and the head of court decides to deploy you in the civil stream, will you be comfortable to work in the civil stream? Do you think you have the necessary experience to do so?
Thank you, DCJ. I was even wondering, when I came here, because I only got an invitation for the criminal stream. In my application, I had indicated though my strength is in the criminal law, I'm willing to jump into civil. I'm willing to learn. It's not as if civil, there's a perception that civil is difficult. But I think it's an issue of practice. We are not practicing it so much that we are used to it. So I'm available if so directed to try, and I can, if others have made it. I know of colleagues that were mostly on the criminal, they have now shifted to the civil. They are doing much better, so it could be an issue of willingness also on the part of the...
Mr. Simasiku, you're emphasizing willingness and availability. Can you talk to capabilities, basic skills?
In terms of experience, civil-wise, for some reason, civil matters in the magistrates' courts are not moving. They don't see their day in courts. So much that in as much as we would have done the default judgments, summary judgments, executions, Section 65 inquiries, those we have done. But to be honest, I have only dealt with one civil trial from start to finality. So other than that, it is just these office-based work that does not take you to court. So it then became worse now that I got appointed to the regional court, because our jurisdiction is more on criminal. We don't get to preside over civil matters.
Yes. Thank you, Mr. Simasiku. Now, we were provided with the number of the partly heard cases that you have when we were given your nomination papers. Could you fill us in on the latest statistics as far as the partly heard cases that you have? And maybe coupled with that is, should you be appointed, how flexible are you to start in the High Court? And I'm saying that in relation to the number of cases that you may be presiding over at the moment. How much time would you require to complete those partly heard cases, if any? And I assume sitting in the regional court, faced with 700 odd cases, you must have picked up partly heard cases.
Thank you, Chief Justice. As at the time when I submitted my application, I think I was standing at plus or minus 30 partly heads. That was around September, October there. Unfortunately, I don't have the figures now of those that I have so far disposed of. This is so because a week before we were invited for the written test, my computer crashed, and then I had to send it to Windhoek for repairs. In fact, I had to borrow a colleague's a laptop for preparation of these interviews. So I did a rough count of what my memory could do, assist me with. It would appear I perhaps would have, between then and now, would have disposed of about 8. There is one that is pending mental evaluation. It was due for sentence, and then we realized that we raised the doubts into the mental capacity of the accused person in mitigation. So that one is also giving me headaches. Of course, in between there, I might have also picked some, maybe about 3 or 4, if I'm not mistaken, that I have added new partly heads. I must state that the reason why I have accumulated so many partly heads is these issues of circuit courts. Previously, you would sit at one place maybe for 2 weeks, then you move before you could finalize it. There was no continuous role. Then you go to Utapi, you start, you can't just stay idle there, you have to start cases there. Then if there are excuses, again, the witnesses did not come, they don't have money, then you have to start another one. So that's how we ended up finding ourselves in this situation. As far as the disposal plan is concerned, I'm sure if notice is given that the appointment will take effect in 3 months, with the willingness of the parties, knowing that I might not be available, we should be able to reduce these numbers significantly. It is also worth noting that maybe about 10 of them, they have not progressed that far. The strategy that we had was that we would allow to take plea at an early stage. So the difficult now is an accused person is just going to admit, for example, the domestic relationship. Now it becomes a partly head by virtue of that admission only.
Right.
So I think the majority of them, they have not advanced so much that even if I become unavailable,
Yes.
the people would then be prejudiced.
Very well.
So I think the ones that are serious, we should be able to dispose of within 3 months. That is if the parties are willing.
Very well. Very well. Thank you, Mr. Simasiku. Now, are you on social media? But please don't specify which one.
Yes, Chief Justice.
Very well. Now, assuming now that you are appointed as a judge, one day you wake up, you see on your social media account, there is this scathing attack on your person from a member of the public, something really said something bad, may I just use that simple language, about you, what would your approach be to such a scandalous attack on your person as a judicial officer?
Thank you, Chief Justice. I don't know whether you are making reference to the last year's utterances or publications that we might have seen on social media. It would depend to what extent. However, it is not up to the judicial officer to then take the debate, particularly on social media. Then you are fighting with this person. That would not be in order with the office of the judge and or judicial officer. The right thing, if at all one would want to take the person to the cleaners, would be to approach the courts so as to have the issue ventilated.
Right. Thank you. Thank you. Now, as we are winding up, I think we have allocated you more time than we should. I think we've exceeded the time allocated to you, actually. Do you have any business interest that obviously you must have declared to the Magistrates Commission and which you think may have an impact on you as a judge, should you be appointed, or at the very least that you think that the Commission should know? Is there anything else that you would like the Commission to know? Something else that we have not asked you?
Unfortunately, none, Chief Justice. I'm not involved in any business activities.
Any farming activities?
Farming, yes, one might have a few. It's tradition that you ought to have even a few. So there we are covered.
Yeah.
Yes.
Or the commercial or subsistence level?
No, not yet, the Chief Justice. God willing, we get to that stage.
Yes. Yes. Okay. So anything else? There are no skeletons in the cupboard, Mr. Simasiku?
Not at all, Chief
No?
Justice.
We don't want to wake up one day after your appointment, should you be appointed,
Yes.
that something else, we read something somewhere and something that you did not disclose to the Commission, that would be a serious omission. So I'm giving you this opportunity to disclose anything else to the Commission that you think the Commission should know.
To my knowledge,
Whether of a personal nature, a family nature.
to my knowledge, there is none, Chief Justice.
There's nothing, there's none.
Yes, Chief Justice.
Well, let's go then. You live in the northern, in one of the northern regions.
Yes, Chief Justice.
And obviously, should you be appointed, you'll have to relocate to Windhoek.
Yes.
It's just so that, as you know, just so that you know, the Commission does actually not provide housing. But what the Commission does is the government gives you a housing allowance that you can utilize to acquire a property of your own. I'm saying this because we have had instances where some demands were made on the Commission. And so we are telling you this up front so that you know, so that should you be appointed, you make the necessary preparations to acquire property of your own.
Thank you, Chief Justice.
Very well. On that score, then, I wish to thank you, Mr. Masiku, for coming in, and good luck. You'll come to the end of the interview for you.
Thank you, Chief
You are
Justice.
excused.
Much appreciated for the opportunity. Wishing the commissioners all the best in their deliberations.
Thank you.
Thank you.
Next will be Mr. Nyazo, Mr. Victor Nyazo. Welcome, Mr. Nyazo, to the Commission.
Thank
You have
Chief
been
Justice.
nominated, you have been called to an interview following your nomination for possible appointment as a a judge of the High Court. And we would like to have a conversation with you today. Just to start off with, if you can introduce yourself to the commissioners and to the nation at large. Who is Victor Nyazo and what makes him tick?
Thank you, Chief Justice. Good morning, esteemed honorable commissioners. I am Victor Nyazo. I would say I grew up in the judiciary, particularly in the lower courts, having been appointed at the age of 23 years in the year 2009. I was fortunate enough that in my final year of pursuing my LLB degree, I joined the Aspirant Magistrates Training Program whilst finishing up my LLB. It was a bit demanding, but I conquered the challenge. Upon completion of my studies, I was then appointed as magistrate at the entry level, my first duty station being Rundu.
Which year was this?
That was in 2009. So I've been on the bench ever since then, and I've risen through the ranks in the lower courts. At the present moment, I hold the rank of Regional Court Magistrate. I'm stationed here in Windhoek at Mungunda Street. Academic-wise, my academic profile is I hold 2 Cambridge certificates, that is grade 12. I hold a certificate in corporate governance from UNISA. I hold a BUris degree from the University of Namibia. I hold an LLB degree from the University of Namibia as well, and a master's degree in criminal law and procedure from the University of South Africa. So overall, I've been a magistrate for the past 16 years and have served the country diligently and with competence in the execution of my duties. So in summary, that's Victor Nyazo, the professional.
Very well. Now, what competencies do you consider you would bring to the bench at the High Court should you be appointed, Mr. Nyazo?
Competence-wise, I would say I bring experience. Having been on the bench for the past 16 years, I believe I can contribute something meaningful to the jurisprudence of this republic, given the opportunity to do so at the High Court. I always ensure that in the execution or pursuance of my duties, I do so diligently and with competence, making sure that I research on what I'm doing. If it's a specific case, do diligent research and then write my judgment with sound reasons. So I believe I'm in a position to contribute significantly to the jurisprudence of our republic.
How many partly heard cases have you picked up to date?
To date, I'm standing at 22 part-head cases that I have picked up, mainly so because when you are seated in trial court, it's inevitable that you'll pick up part-head cases because cases come on a daily basis and the people want to be heard. They deserve justice, they want their day in court. So when you are seated in a trial court, it's unavoidable that you pick up so many cases.
How many are awaiting judgment?
1 at the moment.
Is the judgment overdue or within the time frames provided for delivery?
I would say it's within time frame because I think I reserved judgment, if memory serves me well. That was on the, I think, 28th of February, if I'm not mistaken, yes.
Thank you. DCJ, would you like to ask Mr. Nyazo some questions, please?
No, thank you very much, CJ. I think the most important one is a follow-up to what the CJ has asked you. how do you deal with these 22 cases if you are appointed a judge next month?
Given the opportunity to ascend to the High Court, I would require a little bit of time. And in fact, already when I applied last year for this position, I devised a plan where I had started concentrating mainly on my partly head cases. And as we speak at the moment, the bulk of them are at the defense stage, and some, a few, 1 or 2 or 3 of them are at Section 174 applications, which the attorneys in the matter have decided to bring up. So I would say many of them are at an advanced stage, and
You said a little bit of time. How much time is that?
in terms of time, I would, if I was to estimate, maybe 2 to 3 months, I should be done with all my part-head cases.
Well, the second one is, I assume you are familiar with the Section 302 jurisdiction of the High Court, the automatic reviews that come to the High Court.
Yeah.
Now, as a High Court judge, you are going to do a lot of that.
Yes.
Yes. Now, can you increase a sentence as a High Court judge if you are unhappy with the sentence imposed by the judge Akko?
Strictly speaking, in terms of the law, on review, a High Court judge does not have authority to increase a sentence on review, despite the fact that he or she might have different opinion or might hold different sentiment regarding the appropriateness of the sentence. What matters most is that the sentence should be competent. In other words, the sentence imposed by the magistrate should be within the jurisdiction accorded to a magistrate's court in terms of sentencing. As long as it's a competent sentence, the judge on appeal has no choice but just to confirm that sentence.
Is that the only solution you have? Can you, for example, not confirm, instead of increasing, say you refuse to confirm, and the PG does something about it?
On the judge's part, you are guided by the law, and if the law says if a sentence is competent, you have to confirm, and then you confirm. If the PG is unhappy, perhaps that's an alternative route available to the PG to perhaps maybe appeal the sentence that was handed down by the magistrate.
Thank you. Attorney General.
Thank you, Mr. Nyanzo. In terms of our constitution, Article 26 provides for the state of emergency that empowers the president to make certain regulations under the state of emergency. That will allow you to use weapons in opinion for the protection of national security, public safety, and for the maintenance of law and order. In your own opinion now, would that power or that power entables the president to suspend any laws or statutes or the rights and freedoms that are protected under our constitution?
Just to see clarity, the question is whether if the power accorded to the state president in terms of Article 26 would empower the president to suspend fundamental rights. Yes. My answer would be yes, as long as what's most important is it should be of general application, the suspension of those rights. And when the president does so, if my recollection serves me well of when I read that section sometime, it should be by way of gazette, when the president announces that a state of emergency is now in force and it should be of general application. And yes, some of the rights can be curtailed during that process.
Under which conditions will we do so? If we do so, is it just a blank check?
It's not a blank check. It will state in the Gazette that is to be published specifically what rights are affected and to what extent those rights are affected, and the period within which the state of emergency will be in force.
Now, the concept of equality before the law is something that is also provided for under our Constitution. Article 10 of the Constitution. However, in our law now, can a sitting president be charged with a criminal offense or be subject to any criminal proceedings for either the form or commission during his or tenure of office?
My answer to that would be a definite no. In terms of our Constitution, a sitting president cannot be charged for any criminal offense, and if I'm not wrong, in terms of also civil proceedings. Yes, the equality before the law states that everyone in the eyes of the law is equal, but that is an exception to the rule.
Why is that? Why would that be an exception?
It's an exception because a sitting head of state is the head of the country, and it would therefore be undesirable to have a head of state appearing in court, as that is scandalous, and it would not be good for the reputation of the Republic itself. Perhaps I'm thinking that is what the founding fathers who drafted the Constitution perhaps maybe were thinking of.
Are you then implying that the head of state may under no circumstances appear in court?
No, perhaps it came out wrong. That's not what I'm implying. The head of state may appear in court, but not as an accused or as a defendant, from my understanding of what the Constitution provides.
Yeah. Thank you. I will now invite Commissioner Shikongo to ask his questions.
Only last question. Are you of any jurisprudence in the Republic on that aspect of presidential immunity when it comes to criminal prosecution during his reign?
In this jurisdiction, I would say I haven't come across a case that speaks to that so far, unfortunately. And beyond as well, perhaps I would not want to distort facts, but I've seen it in our neighboring country with the former president Zuma having appeared in court in some instances, but I do not know on what merit, so I cannot say it with authority.
Of course, the Constitution is the guiding document, the supreme law. So one has to familiarize themselves with the Constitution, what the Constitution says on that aspect. But Commissioner Shikongo, you may continue, please.
I'm sure if you carry a spending over 16 years, you would have found that the instance where the state is challenged with lack of evidence, let's call it circumstantial evidence as opposed to direct evidence. How would you normally go about assessing that circumstantial evidence where the state cannot discharge honors with direct evidence?
There is ample authority from this jurisdiction on circumstantial evidence. The approach, in fact, the locus classicus on circumstantial evidence would be the Arves Blom matter, where When you are confronted with a case, upon evaluating the evidence and you arrive at the conclusion that it's circumstantial evidence, you have to look at all the possibilities on the available evidence and exclude each and every possibility except for the one that will remain. And if the one that remains proves beyond a reasonable doubt that the accused person is guilty, then as a judicial officer you have to return a guilty verdict. It differs completely from the civil arena where the most likely possibility is the one that you can go with. But in criminal law, you have to exclude each and every little possibility that might be there. And the one that you are left with, if it points to the accused being guilty, you go with that. If it points to the accused being innocent, you acquit.
How do you reconcile it with the burden of proving the crime beyond any reasonable doubt?
Yes, the burden doesn't change at all because it remains with the prosecution. They are alleging that this particular person committed this crime, and therefore the burden remains with them. And as such, in the process of evaluating evidence, that's why you have to come to a finding that despite it being circumstantial evidence, you have excluded all the other inferences that could be drawn, save for the one that you arrived at, and that is beyond doubt the only inference that can be drawn.
Thank you, Mr. Moore. I believe you will agree that departure from mandatory sentence will be the exception to the rule.
Indeed.
Now, you will take into account circumstantial and compelling circumstances in depart, if at all you want to explore that avenue. How do you consider that?
I'll take a pragmatic approach to it. When I'm seated in court, say for instance it's a rep matter, and the accused person has been found guilty and it's during pre-sentencing proceedings, the court is duty-bound, mostly where an accused is unrepresented, to bring it to the attention of that accused person to say there are prescribed mandatory minimum sentence applicable in this particular instance. Be alive to that, and as a court, I expect you to inform me if there exist any reasons that is substantial and of course compelling for me to deviate from the prescribed minimum. I would want you to inform me of such so that I can record that. Now, after having been informed by the accused, obviously the prosecution will get an opportunity as well to present evidence, be it in rebuttal, whether if they are in concurrence with the accused that there exist or does not exist substantial or compelling circumstances. And when I sit to write my pronouncement on sentence, I would be guided by generally what has been presented before me by that particular accused person, be it his personal circumstances, be it conditions pertaining to maybe the manner in which the crime was committed, anything of significance that has been presented by the accused, and I would sit on that and then decide, is it deserving, does it meet the threshold as provided for in terms of the law, and also through guidance, through case precedent, on whether if I should depart from the prescribed minimum sentence. What I would be looking at is cases like S. Lopez and the famous Malgas case, which admonishes judicial officers not to lightly depart from imposing these minimum sentences, because they do serve a very important purpose. That is why the legislature saw it fit to have them enacted, and not just to have judicial officers exercising their discretion, which can only be retained if satisfied that indeed there exists substantial and compelling circumstances.
The key then is the notion of substantial and compelling circumstances.
Yes.
That is the key. So what is it that will constitute such?
Yes.
By way of example.
By way of example, as I was saying, it's a totality of everything that is, it's nothing unique or peculiar. Generally, it's what is being presented before you. You look at that collectively or cumulatively, and then you apply your mind to it, and then make a determination, of course guided by the law, whether if such constitutes substantial and compelling circumstances.
So you wouldn't say that there is no numerous clauses on those circumstances?
No, there isn't.
Thank you. Commissioner Campbell, then, please.
Good morning.
When you transition from the Magistrates Court to the High Court, you will find yourself often sitting as a judge of appeal in the High Court. When you sit as a judge of appeal against, in an appeal against sentence only, and on the day of the hearing, the unrepresented accused informs you that he wants to hand you documents to also appeal his conviction, not only his sentence, which is before you. How will you handle that situation?
Thank you. At that stage, I would say it would be, unfortunately for the unrepresented accused, be a situation of him bringing that to the attention of the court at the 11th hour. It's already too late because he's bound by the papers that he filed with the court. So if he has had a change of mind in the interim or meanwhile, what I would advise the unrepresented accused would be to withdraw his appeal, go back, and then draft a fresh notice of appeal that would include an appeal against the conviction and not only the sentence, and then file it and institute the process from the start.
Very well. After you've explained that process or the available options to the accused person, he informs you that he elects only to proceed with his appeal against sentence. But when you read the court record from the court of first instance, in your mind, it appears to you that the conviction was incorrectly given. What would you do under those circumstances?
That's quite a unique scenario. Under those circumstances, if an accused insists that he would only want to proceed against the appeal against sentence, it's his prerogative to do so. However, I would try to impress upon him, because my sense of justice would not allow me to let it be. I would try to impress upon him that perhaps he should consider withdrawing the appeal and lodge a fresh a notice of appeal that would also attack the conviction. But to go further or beyond that, I believe would be descending into the arena, as it were.
Does the High Court have inherent jurisdiction to consider the conviction also?
The High Court is a court of unlimited general jurisdiction. However, in this particular instance, what would come to mind is there is a specific issue outlined before court by a particular litigant, I would say the accused, and it is that he is only attacking the sentence. So, despite having that inherent jurisdiction, as a presiding officer, you cannot on your own now start inviting or bringing in issues which are not before you for consideration.
Very well. Are you familiar with Section 61 of the Criminal Procedure Act?
Indeed.
Section 61 deals with bail under circumstances where there are more serious offences. contained in that section are phrases, or is one would find the phrase, in the interest of the public or the administration of justice. Can you explain to us what you understand under that particular phrase?
Thank you. In recent time, it was last year, I think, that was an issue of discourse in our courts in the matter of Ngipunya as the Minister of Justice. In fact, that judgment resulted in one dissenting judgment and one majority where, if I'm not wrong, it was Judge Masuku. The definition of public interest and administration of justice is too broad and vague. There needs to be certainty as to what it entails exactly. And I think he went on further to recommend that perhaps maybe our jurisdiction should look at what other jurisdictions are doing. If I recall, he mentioned Eswatini and I think other jurisdictions as well, where they have clearly defined what the concept of public interest means, or the interest of administration of justice. The majority judgment, on the other hand, was that the words public interest and administration of justice are couched in such a manner in the law itself, so much so that it allows the presiding officer to use his or her discretion, given the set of facts presented before that particular judicial officer, to make a determination whether, on the available facts, the interest of the administration of justice or public interest dictates that an accused person be admitted to bail or be denied bail.
Which view do you prefer, minority or majority?
To be quite honest, I'm with the minority.
You are with the minority?
Yeah.
I see. Which one binds you?
I'm bound by the majority.
Now, can you briefly tell us what is the doctrine of precedent?
Doctrine of precedent, building on what I've just said now, and on your question, the last question, DCJ, it means that for me, who's seated in a lower court, I'm bound by the decisions of firstly the Supreme Court and the High Court. I cannot deviate from that. If I take it further, if I was sitting in the High Court, I'm bound by the decisions of the Supreme Court. And then you have certain scenarios where, still within the High Court, there is a judgment, you have conflicting judgments on a particular issue. Then you'll have a judgment where two judges sat versus a judgment where perhaps a single judge sat. The one where two judges sat carries more weight than the one where a single judge sat, and therefore, if I'm seated as a single judge, I'm bound to follow the judgment that was delivered, constituted by a full bench, as it were.
Sorry, CJ. Does it mean if there was a single judge and you are also a single judge, you are not bound by a decision of your colleague?
You are. The exception would be if my colleague was completely or totally wrong on the law in that judgment. In that case, I would be justified not to follow that judgment.
Who determines whether your colleague was wrong or right?
The determination is just, from my point of view, when the case is presented before me, and then I go through the case and then come to the realization that the application of the law in this particular case was not done in accordance with justice, or was not properly done, or my colleague erred. In that way, I would be justified to not follow.
What about when acting on facts as opposed to just law?
Pardon me?
What about an error on facts as opposed to?
Oh no, error on facts, that would not be a reason enough to not follow that decision. It has to be misapplication or perhaps, I would say, gross misinterpretation of what the law is. One cannot easily, just at slightest whim, say, my colleague came to this decision, I will not follow. It has to be exceptional, if I can put it that way. For example, if the Criminal Procedure Act provides that an accused person should be accorded the opportunity to mitigate, and then in that particular case, the presiding officer decides when it comes to the mitigation pre-sentencing phase, 274 of the CPA gives or empowers either party, prosecution or accused, the opportunity to mitigate. So if in that particular case a judge comes to a decision that no, in this particular instance you are not allowed to mitigate, if I'm presented with a case precedent of that nature, surely that would be totally wrong, and I would not be justified to follow that.
Very well. So, finally, Mr. Nyazo, is there anything else that you'd like the Commission to know, something that you consider to be important, that you can't leave this venue without informing the Commission?
Perhaps maybe I can say I was also caught by surprise in recent time when I read an article in the newspaper to the effect that a complaint had been laid against me with the JSC, the Magistrates Commission, and the Ombudsman by an accused in a particular case that I had dealt with. All that I can say to that is, as a judicial officer, I'm required to decide matters. I applied my mind in the particular matter and decided the facts, on the facts, presented before me, and arrived at a decision. And the complainant in that matter perhaps was aggrieved and did exercise his right to appeal. And of course, on appeal, the High Court, on the available evidence, came to a different conclusion. And in that judgment, if one would take time to read that judgment, nowhere did the High Court say that I was biased in my adjudication of the matter or that I was incompetent. In fact, to the contrary, the judge commented that the magistrate had meticulously addressed or evaluated the evidence. That's what I would like to say or set the record
Very well.
straight. Thank you.
Thank you for pointing that one out. I expected you to point it out. Yes. And any other disclosure, any financial interest that you may have elsewhere that may impact on your work as a judicial officer at the High Court level, or at any rate that you think the Commission should nevertheless know?
Frankly, no, Chief Justice.
You are not involved in commercial enterprises like businesses, commercial...
No, not business.
Farming? What about farming? Are you covered also?
No, I'm still trying to work my way up to there. Yes. But
Maybe I'm still farming is not business.
Yeah, very well. Yeah. Very well. Thank you so much for coming, Mr. Yes, I'm reminded of a very important thing. It may seem innocuous, but it's important. And that is to say that should you be appointed, please do not have any expectation to be provided with housing from the Commission side or the Office of the Judiciary side. That's really a facility that we do not have as a Commission. But as you know, government provides a judge with an allowance to purchase property of his or her own. And that is really the facility that one should make use of should one gets the nod to get appointed. It's just a formality that I thought we should let you know
Thank you.
because of the past experiences that the Commission has had on that aspect.
Thank you, Chief Justice.
Other than that, I wish you all the best with the outcome of the interview, and thank you for coming.
Thank you, Chief Justice, for the opportunity. I must say it was intellectually stimulating, starting from the first round up to this round. Thank you very much.
Thank you. Thank you. Good luck. $20? 20 minutes? Yeah. No, yes. We will now have a break of 20 minutes. We resume at 11:15. Okay. We will adjourn.